Good day, Crime Talk aficionados. We have a great show for you. First, privacy concerns in the Kohberger case. Authorities allege that California infant was slain up to 9 days prior to the fabricated abduction story. We have a Donna Adelson trial update. And guess what? This guy has an extensive criminal record, who's the suspect in a murder of a Ukrainian refugee. We have This Day in Legal History, legal quote of the day regarding prosecutorial discretion, and our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, and hit that little bell for notifications. And remember, you can check us out on any of your favorite podcasting apps. Now, before we get to the show, let me remind you to go to crimetalksearch.com, sign up for that background subscription service today. When you do, you'll be able to do as many background searches on anyone here in the United States. Here's the beautiful thing. The report is literally prepared while you wait. And then it's emailed to you, and you're going to find out telephone numbers associated with the person, email addresses, social media presence. You're going to find out if they have, a spouse. Do they have liens, judgments? Do they own property? Married, divorced, criminal history, sex offender registries? That's right. Everything you want to know about somebody either coming into your life or whether you need to make the decision of whether they need to get out of your life. Go to crimetalksearch.com. You're going to be happy that you did. All right, ladies and gentlemen, sorry for the show getting up a little late today. It's all my fault. Guess what? Had to go to court, do that legal thing all day in a hearing. And it's been a day. So let's get to the show. All right. First on the docket, some new developments in the Brian Kohberger case involving some privacy concerns. And guess what? We have a neighbor's account of what he heard the morning of the murders. So a privacy battle over some crime scene evidence. The legal representatives for relatives of two victims in the Brian Kohberger case, Madison Mogan and Ethan Chapin, has advanced or advocated strongly for restricting public access to any photographic or video records from the crime scene. Leander James, the attorney, appeared on a program with criminal defense expert Randy Zellen to address the issue prior to a key hearing scheduled for Thursday, tomorrow, where the families will make their final appeal to maintain the confidentiality of such materials. Now, James emphasized that established legal precedent in Idaho and other jurisdictions prohibits the dissemination of images depicting death scenes. He said these materials have not entered the public record since the case did not proceed to trial and were never introduced as evidence. And he stated during the Tuesday interview, and he argued that the releasing of these photographs would cross an unacceptable boundary, though he acknowledged that the decision regarding other types of imagery could become contentious during the upcoming proceedings. Now, Zellen agreed that preserving the privacy of these images aligns with emotional, moral, and ethical considerations. However, he highlighted the legal challenges, noting the fundamental principles of openness in the United States justice system. Judicial transparency is presumed in both civil and criminal matters. And he pointed out that the documents or evidence reviewed by the judge for the plea changes or sentencing purposes are typically considered public, fostering trust in the judiciary and the prosecution. Well, this creates a significant legal conflict for the affected families. Ladies and gentlemen, I get it. Privacy concerns, morally, should it be sent out there? Yeah. Let me tell you, somebody told me today, if what my side was advocating for, it was immoral, what we asked for. And the guy told that to the judge. And, my position is, Judge, you want morally, you go to church, okay? But there's a legality. And I've always said there's a difference between morality and legality. What you think is morally right and wrong is not necessarily what is legally right and wrong. And when you're in court, you're dealing with legal issues. Now, do I personally feel the need to see all the crime scene evidence? No. But do I think it should be released? Probably. Now, would you hope that people would be respectful and treat it in a ethical manner? Yes, I would hope so. We would not post those. I can't imagine that we would ever post those or even put them up on our website. But you can find anything on the internet. You just have to go find it. These crime scene photos, I get it. They're going to be disturbing. But if you don't want to, in an open society, you have to be able to let people see things that they may not want to see. And guess what? The beautiful thing is they can decide whether they want to see it. So if you're a free speech advocate, sometimes things are going to be out there that you may not necessarily like. Now, what do I think Judge Hippler will do? I think he's going to try to split the baby. He says the public has a right to know in various other things, and he's very open to that, and I think that's appropriate. But I think on this one, he's going to try to tailor something that lets people see something, but maybe they're going to be somehow redacted. And maybe that's how it's done. But I think ultimately they're going to be released in some form, perhaps a redacted form. Next, we have a neighbor report some suspicious incident linked to the murder. So in a separate revelation from court documents, a University of Idaho student and neighbor to the victims reported a potential encounter with the perpetrator on the morning of November 13th of 2022. So according to the Idaho State Police report, the young man who lived near the crime scene, 1122 King Road, informed the authorities that he suspected Brian Kohberger of approaching his home shortly after the murders. The neighbor described spending the evening playing video games with fraternity members until about 4:30 in the morning. He then drove home, parked near the victim's residence, and walked his dog along the street, noting a barking dog, possibly the golden doodle belonging to the victim, Kaylee Gonsalves. The faint music was also in the background. Anyway, his route ended at the cul-de-sac south of the house where the four students were fatally stabbed. Upon returning home at approximately 5 a.m. and settling into bed, he heard tapping sounds on a window near his front door. Peering through the blinds, he saw no one. Following the public release of the probable cause affidavit detailing Kohberger's movements, the neighbors contacted police, believing the incident might involve the suspect. Now, the affidavit indicates Kohberger was captured on a security camera, leaving the area rapidly at about 4:20 a.m., with his cell phone later pinging in nearby locations, including Uniontown, Washington, around 5 a.m. and Genesee, Idaho, shortly before that. So Kohberger reactivated his phone and made multiple calls that morning to his mother, starting at 6 a.m., including during a return drive to the vicinity of the crime scene. And although police documented the neighbor's statement as evidence, no further investigative action on the specific report are noted in any available records. Obviously, this case is going to continue to draw attention, and any news information that comes about, well, I think it's a somewhat relevant. But if you heard our live last night, we had another attorney call up and said, well, this one little thing about the car, and he could be innocent. And I kept saying, he pled guilty. He pled guilty. Next on the docket. So police allege that the California infant was slain up to 9 days prior to the fabricated abduction report. That's right. Prosecutors have disclosed alarming details in the investigation into the death of 7-month-old Emmanuel Haro, asserting that the infant may have been deceased for as long as 9 days before the mothers reported a staged kidnapping. Now, the child's parents, who are facing murder charges, made their initial court appearances on Tuesday amid an ongoing search of the boy's remains. Court records indicate that Emmanuel is believed to have been killed between August 5th and August 14th of this year, and on the latter date, his mother, Rebecca Haro, contacted police to claim that an unknown assailant had attacked her and abducted the infant from their vehicle in the parking lot of the Big Five sporting goods store in Yacapaya, California. She described the incident as occurring while she was changing the child's diaper. Now, law enforcement officials quickly identified discrepancies in the accounts provided by Rebecca and her husband, Jake Haro, and the couple ceased cooperating with the investigation and engaged legal counsel, prompting a shift in the probe from a missing child, to possible homicide inquiry. Anyway, evidence suggests no kidnapping occurred in the city, stated the San Bernardino County Sheriff's Department in a press release last Friday. They said it is their belief that Emmanuel is deceased, and efforts to locate his remains continue. Well, the parents were apprehended during a search of their residence on August 22nd and charged with murder involving malice aforethought, as well as filing a false police report. Now, Jake Haro's vehicle was impounded as potential evidence 3 days earlier. And surveillance footage and witness statements revealed that Rebecca Haro had visited the same store the day leading up to the reported abduction, inquiring about external security cameras and alleging a prior vehicle break-in in the parking area. 2 days following their arrest, Jake Haro was observed in an orange inmate uniform accompanying authorities in the search operations along a remote stretch of highway in Moreno Valley. Despite these efforts, Emmanuel's body has not been recovered. The Haros, who also share a 2-year-old daughter, appeared in the Riverside County Superior Court on the 26th without private counsel. Their previously retained attorney did not attend, leading to the assignment of a public defender. No pleas were entered, and the arraignment is set for September 4th, when separate legal representation is anticipated, also known as public defender, and then private counsel for the other party. Can you believe it? They lied? Oh my gosh. Anyway, Rebecca Haro has publicly asserted her innocence, and will give her the presumption of innocence. And she has emphasized her desire to participate in the search of her son. In a statement to regional news outlets on Sundays, she declared, "I want to be out looking for my baby. I will not give up on my baby." She further insisted that her husband would never harm a child. Well, guess what? Jake Haro has a prior criminal record, having served a 6-month sentence for child cruelty related to an incident back in 2018. He actually was on probation at the time of this alleged offense. Additionally, Rebecca Haro's brother, James, is serving a minimum 50-year prison term for the 2017 murder of his girlfriend, which he attempted to disguise as a suicide. If convicted of murder and malice, the couple would face life imprisonment without the possibility of parole. Obviously, the investigation continues. Next on the docket, an Adelson trial update. So we had the morning session. The trial commenced with Assistant State Attorney Sarah Catherine Dugan continuing her examination of the Tallahassee Police Department Sergeant Christopher Corbett. He presented cell phone records and located data linking the hitmen Sigfredo Garcia and Luis Rivera to a rental car agency and their journey from Miami to Tallahassee. Evidence included a traffic citation issued to Garcia and communication among Donna Adelson, her son, Charlie Adelson, Catherine Magbuana, and Garcia on the day the hitman traveled but did not execute the murder. Corbett also detailed text messages between Don Markle and his ex-wife, Wendy Adelson, regarding Markle's schedule, which aligned with the timing of the crime. On the morning of July 18th of 2014, the day of the murder, records showed calls between Donna and Charlie at 1 a.m., followed by a call from Donna to Wendy at 8 a.m. Location data placed Garcia and Rivera near Markle's gym, Premier Health and Fitness, shortly before the shooting. There's never coincidence in criminal law, ladies and gentlemen. Additionally, Wendy's phone activity indicated she was near Markle's home during the incident, but did not contact him, the children, or authorities despite encountering a police roadblock. Then they broke for lunch. Examination resumed of Sergeant Corbett following the lunch break, and defense attorney Josh Zellman cross-examined Corbett, focusing on the limitations of the cell phone data, such as signal quality influenced by proximity to the towers, topography, and buildings in the area. Zellman highlighted that call records do not confirm successful connections or reveal content, noting 80 calls or attempts between Donna and Charlie from June to July of 2014, which Corbett deemed not unusually high. Only 4 communications occurred between July 16th and the 18th of 2014. Zellman questioned emails and texts about a birthday party to Harvey Adelson, potentially interpreted as code by the state, and explored Donna's travel time to the murder on that day, suggesting delay due to traffic or stops. Corbett acknowledged uncertainties in exact locations and speeds, and after a brief redirect, Corbett concluded his testimony. Then we heard from the undercover agent and FBI personnel. So an undercover agent testified about the bump operation back in April of 2016, where he approached Donna Adelson outside her Miami condominium, posing as a Latin Kings gang member demanding payment related to the murder. He handed her a flyer with a phone number and later sent an aggressive letter seeking $5,000, but she did not respond initially. On cross-examination, the defense attorney inquired if the approach startled Donna, which the agent confirmed. FBI Special Agent Luis Bronstein discussed surveillance of the bump and a 2016 recording of Charlie Adelson and Catherine Magbuana at the Dulce Vita restaurant, noting audio challenges due to background noise. Audio engineer Keith McLevin explained his forensic work to clarify the Dulce Vita tapes, describing extensive interference from restaurant sounds. And former Special Agent Brian Kendall testified about covertly recording Charlie and his father, Harvey Adelson, at a Miami sushi restaurant. And FBI Special Agent Pat Sanford provided details on wiretap calls and the bump, including instructions to the undercover agent to avoid aggression. Recordings played in court included conversations between Donna and Charlie post-bump, where they discussed the encounter cryptically, mentioning blackmail and a TV reference tied to prior jokes about hitmen and Wendy's alibi. Sanford noted Donna did not report the incident to police. Additional calls involved Charlie and Magbuana with unsuccessful attempts to record their in-person meetings. Sanford also referenced an interview with Rivera about the murder weapon malfunctioning en route. The session ended a little early at the request of the state's attorney, as Sanford's testimony was anticipated to extend significantly. The judge recessed court, instructing everybody to return tomorrow morning at 8:30. Now, we're bringing you this trial, so make sure you go and check it out and watch it. It's quite interesting. I missed today, but guess what? I'll watch it tonight. Next on the docket, a suspect with an extensive criminal history. Yeah, could you imagine? So a 35-year-old man charged with the fatal stabbing of a 23-year-old Ukrainian woman who had recently relocated to the United States to escape the conflict in her homeland possesses a substantial history of criminal offenses, according to law enforcement. Now, DeCarlos Brown is accused of murdering Irina Zarutska at the South End Light Rail Station in Charlotte, North Carolina, on the evening of August 23rd of 2025. Police apprehended him shortly afterward, and he received medical treatment for minor injuries before being formally charged with first-degree murder. Now, Zarutska's relatives described her move to the United States as a pursuit of security and a fresh start amid the ongoing war. Now, police records reveal Brown as a repeat offender with frequent incarcerations, and in January of this year, he faced charges for improper use of emergency services after claiming exposure to a substance that manipulated his behavior. He was released without bond and awaited trial at the time of the alleged homicide. Now, Brown completed a 5-year sentence for a 2014 armed robbery, exiting prison in September of 2020, after which he promptly re-engaged in unlawful activities, and in February of 2021, he was detained for assaulting his siblings, resulting in a minor harm, along with separate arrests that month for property damage and unauthorized entry. A report detailed his return to a prohibited residence where he forcefully damaged the entrance. Further incidents include a July 2022 arrest for disruptive behavior during a domestic dispute involving loud verbal outbursts that disturbed neighbors. Now, Brown's criminal involvement dates back to 2007, encompassing at least 6 arrests through 2014. Now, the district attorney's office declined to comment on the active investigation, but affirmed a general policy of detailing individuals accused of violent acts pending trial. Anyway, this incident represents Brown's gravest allegations to date, and officials have not disclosed the motive behind the stabbing, but local police officials have called for transparency from authorities, emphasizing eroded public confidence in transit safety and the need to reassure riders and support the victims' families. Now, Zarutska's kin highlighted her passing as a profound tragedy, and on their fundraising platform aimed at covering unforeseen costs related to her aunt and others. Her relocation followed Russia's 2022 invasion of Ukraine, and obviously, we know how that peace negotiations are going. Not so great. Next on the docket, this day in legal history. August 27th, 1881. New York's state's pure food law goes into effect, aiming to prevent the adulteration of food or drugs, marking an early state-level regulation on consumer protection and public health. What do I tell you, ladies and gentlemen? When you go back and look at all the history stuff, it's nothing new that we deal with today. We just repackage it. It's all the same. 1894, the United States Congress passes the Wilson-Gorham Tariff Act, which included the first peacetime graduated income tax. This provision, the income tax, was later struck down as unconstitutional by the United States Supreme Court in Pollock v. Farmers Loan and Trust. That's an 1895 decision if you'd like to go check that out. Yes, the days before there was a federal income tax, ladies and gentlemen, they had to pass an amendment to the United States Constitution to make it legal. Next on the docket, this date, 1950, actress Jean Muir is blacklisted by General Foods from the TV show The Aldrich Family due to alleged communist sympathies, exemplifying McCarthyism's impact on freedom of association and due process rights during the Red Scare. See, ladies and gentlemen, nothing's changed. There were communists back then. There's communists today. Until they're all defeated, they'll still be communists. Next, 1976. Transgender tennis player Renee Richards is barred from competing in the U.S. Tennis Open after failing a gender test, leading to a landmark lawsuit she won in 1977, advancing transgender rights in sports under anti-discrimination laws. See, ladies and gentlemen, this case goes back to 1976. Nothing's changed. We just keep repackaging everything. Next, this date, 1996, California Governor Pete Wilson signs an executive order halting state benefits to illegal immigrants, influencing debate on immigration policies and state-federal relations regarding welfare and residency rights. Nothing's changed, ladies and gentlemen. Same arguments. They just repackage it. This date in 2007, NFL quarterback Michael Vick formally pleads guilty in federal court to felony charges related to operating an interstate dogfighting ring. Yep, that got him 23 months in prison, and obviously not good animal cruelty. But don't worry, when he got out, he was still able to play a little bit longer because you can look past all those little transgressions in life if you can throw a ball well enough. Next, our legal quote today has to do with prosecutorial discretion. The quote is, the decision whether or not to prosecute and what charges to file or bring before a grand jury rests entirely in the prosecutor's discretion. Now, this quote is from the United States Supreme Court opinion in Borkenkircher v. Hayes, a 1978 opinion from the United States Supreme Court. Anyway, in that case, Justice Potter Stewart stated that the court addressed the scope of the prosecutorial discretion during plea bargaining, emphasizing that prosecutors have broad authority to decide on charges provided they do not violate constitutional protections such as those against vindictiveness or discrimination. And this principle underscores the executive branch's role in law enforcement while highlighting limits to judicial oversights. Nothing changes, ladies and gentlemen. It's all been argued before. And next on the docket, our dumb criminal of the day. So yesterday at about 10:45, in the dead of the night, when most folks are tucked in bed dreaming of brighter ideas, one Ocala, Florida resident decided to play a risky game of tag with the skies. Please meet Adam Santiago Lugo, who found himself on the wrong end of the handcuffs after allegedly directing a green laser beam at a Marion County Sheriff's Office helicopter, all in the name of combating boredom with what he dubbed as, well, just being silly. Silly. Anyway, the incident unfolded around 2 a.m. during a routine aerial security patrol near the southwest 154th Lane Road and southwest 58th Terrace. The chopper crew reported multiple strikes from the laser, which momentarily blinded the pilot and turned a standard flight into an impromptu light show of the hazardous variety. Not one to be outshone, the aviation team deployed their high-tech, forward-looking infrared FLIR camera to pinpoint the source. Lo and behold, it zeroed in on Santiago Lugo, lounging in his driveway, armed with binoculars for a better view and the offending laser pointer for his ill-advised entertainment. So even as ground deputies closed in, the suspect reportedly persisted with his beaming behavior, adding a dash of defiance to the mix. Upon confrontation, he briefly resisted arrest, perhaps hoping for a dramatic getaway, but ultimately surrendered without escalating the folly further. In his post-arrest chat with the police, Santiago Lugo confessed that sheer tedium had inspired his celestial mischief. The sheriff's office, unamused by the explanation, confiscated the laser pointer, binoculars, and the accompanying flashlight as evidence of his nocturnal naughtiness. Guess what? Now he's charged with a felony of aiming a laser at an aircraft pilot and a misdemeanor for non-violent resistance to arrest. Santiago Lugo's tale serves as a luminous reminder. What starts as a silly whim can swiftly illuminate the path to legal troubles. As a pilot, ladies and gentlemen, don't do that. It seriously blinds pilots. It's super dangerous, and you should probably go to prison for that, particularly the fact that you're interfering with police officers in this particular case. Anyway, Mr. Lugo, you are a dumb criminal of the day. Congratulations, you made it. I hope things actually work out well for you, but it's so dangerous. All right, ladies and gentlemen, that's all we have for today. Thanks for watching. We'll see you next time. And remember, the Constitution matters.